Good afternoon, folks. It's 1:30, and we'll call this meeting back to order. This time, we're going to just pick up where we left off last night, and then we'll turn it back over to Xcel Energy.
I think we're doing different microphone this afternoon. Thank you for having us back to continue the conversation regarding Colorado's Power Pathway. I think what we'd like to lead off with today is for Patrick to talk about wildfire, some of the questions about weather stations and so on that were provided last night.
Good afternoon. You guys can hear me okay? So my name is Patrick Karedish. I work for Xcel Energy. I support our transmission operations organization in the area of wildfire. I do that for Colorado, and I do that for all of our operating companies, which stretch from around Carlsbad up to Canada. Before I make any statements from yesterday, I'd like to thank the Commission for having us. I'd like to thank those who came out yesterday to speak. Appreciate the comments. You are heard, so I want to say that. And when we talk about wildfire, we talk about the concerns around wildfire. Again, you're heard on those concerns. Us as a company, we do take that extremely seriously. That's why we filed 2 wildfire mitigation plans, one back in 2020. We've re-upped and filed one for 25 to 27. We continue to make investments in Colorado in the area of wildfire. So again, we understand the concerns, we hear the concerns, we do take that seriously. On that, wanted to touch on a few questions and comments that came up yesterday to hopefully provide some clarifications. First is, we talk risk of transmission lines or power lines causing sparks and arcs and different failures. We tend to blend together transmission and distribution lines. And there's a significant difference between a transmission line and a distribution line in failure rates. And during the Planning Commission meetings, I think there was a great statement that was made by one of the commissioners that was a firefighter for 35 years, was a retired lineman, and had mentioned that they had never seen a transmission fire before, and I think at that time was trying to help to provide some clarification, right, that there is a distinct difference between that transmission line and a distribution line. So I appreciated those comments, and I know he was trying to provide some clarification at the time. A statement or a question actually that came up from the audience yesterday was on weather, and was what are the different software platforms we use for weather monitoring? And so not necessarily my area of expertise, but I did reach out to our meteorological group between yesterday and today, and we use about 8 different weather models. 8 are more long-term forecasting, 8 are short-term forecasting. So we talk long-term forecasting, we're talking days to weeks. We talk short-term forecasting, that is hourly to days. And so we use a combination of these models to look at weather conditions, more specifically fire weather conditions, and are looking to make determinations on, for our, distribution or transmission systems. Do we need to change the way we operate the system, for example, on a certain day, given fire weather conditions? And so we have an internal meteorological group. I believe we have 4 meteorologists right now that are constantly or constantly watching weather, and are making, again, long-term forecasting, but again, up to the day are making those decisions on, do I operate a transmission line, for example, differently today than I would during a lower risk day? So I have some acronyms or some different software models I can provide. I'm not sure if that's of value or not, but we do use a combination of around 8 different models. Another item that was brought up that clarification might be helpful on is, we had mentioned we monitor our lines 24/7. And what does that mean, right? We provide 24/7 monitoring of our lines. And I think that means a few things. One is we have what we consider to be redundant or dual protection systems. So we have a primary system and a backup system that are consistently looking at electrical characteristics on our line and trying and working to identify, is there an abnormal condition? And if so, those protection systems take action. And that can result in just the de-energization of the line. And so that is a system that is, these are systems that are installed at our substations that are constantly monitoring our lines. So if abnormal conditions happen, protection systems are going to take an action. In addition to that, our control center is monitoring, has that line taken an action? Right? Did that line de-energize? If so, we're going to dispatch, right? We're going to dispatch somebody out here to inspect the line, determine, what might be the cause of that, to determine if there's an abnormal condition. In addition to that, we have situational awareness such as Pano AI that through AI is going to be monitoring, is it sensing a smoke or any sort of fire-related condition? And so this is similar to what had happened in Douglas County recently, where Pano AI was able to pick up on, smoke, and they were able to respond very fast. And I think on that Pano AI as well, we are working with local OEMs and fire departments for you guys to get access to Pano AI. And so I think that's going to be a tool, regardless of the outcome of this proceeding, that you guys will have access to. So I think that is going to be a useful tool for you, again, no matter where we end up today. And I think the last item I wanted to touch on that this is discussed a little bit in one of the exhibits that was presented and by a few folks from the public, is the idea of, making sure, are we going to inspect our lines? Is there, do we have regular programs that do this? And I think the answer is yes. Right? We have a regular cadence of inspections on all of our transmission lines. We have that today for all our transmission lines. Pathway would be no different. So we have a regular cadence of inspection on those lines. If we identify anything needs to be, any issues or repairs that need to be made on that line, work plans will be created for those. So that's a plan we already have in place across our transmission lines. That the line that pass through your county would be no different. So I hope those are helpful, and appreciate your time.
Great, thank you. A couple other items to touch on. Wanted to provide a little bit of an explanation. There was some description provided in the staff presentation, and Patrick touched on this. The purpose of a transmission line like Pathway in the electric system, there I think is maybe some question around the fact that this line doesn't serve Elbert County directly. And as a bulk transmission line, it wouldn't serve customers directly. Its purpose is to move power from generation sources to places on the grid where it is then stepped down potentially to different voltages to be moved around even further, and then ultimately to distribution substations. Colorado has an interconnected grid system, so each utility is not on its own system. They're all connected. So that includes transmission companies, generation and transmission companies like Xcel Energy. Tri-State is another G&T in the state. Tri-State serves a number of co-ops in certain parts of the state, and Xcel Energy has our own distribution system. So we have a number of connection points in that interconnected system where other utilities also connect at those substations, or in some cases those generation facilities, and move power on their transmission lines to serve local communities that are within their service territory. Pathway doesn't change the service provider in any local community along the way, but it does provide power to the bulk electric system in that interconnected grid. Other utilities in Colorado can choose and request to connect to the Pathway line or to Xcel Energy's system because we have an open access transmission system, and move power, add power, pull power from that system. As such, that interconnected system and pathway being part of that provides a benefit to all electric consumers in Colorado, contributing to that safe, reliable system that everyone depends so much on for home, business, life-saving purposes as well. So I wanted to make sure that was clear in terms of the purpose of the line and the role it serves in that transmission system, and the benefit more broadly than even specifically to this community, but also to this community. Questions about condemnation and condemnation timing relative to permitting and how that stacks up, how that plays out. Why does it feel out of order here, maybe in terms of what folks would expect? And to talk about that process a little bit more and explain, as we plan our projects, we have to put schedules in place that account for the years it takes to route a transmission line like this, to acquire the land, to get not only the land use permits, but also the other associated construction permits, things like right-of-way agreements or road use agreements, those sorts of things, as well as the information that we have to collect to design the line. Every transmission structure on pathway and lines of this voltage are designed for the location that they're placed. They're not off-the-shelf, so to speak, transmission poles, and so the foundation and the design of that pole very much depends on us being able to access properties, to perform geotech studies, for example, to conduct the necessary biological studies, wetland reviews, and so on that require us to really have people on the ground. And that timing, when we back that out from where we need to start construction to hit our required in-service dates that the PUC holds us to, we see that the schedules start to overlap. It's not linear. We don't conduct a routing study and then acquire the land and then permit it in that linear sequence, one starting after the other, or to reverse that even, to route a project like Pathway, acquire the land use permit first, and then conduct the land acquisition work. That would double, triple the time that it takes to develop a project, which simply doesn't exist when you have a project like Pathway and the purpose that it serves, and the requirements for not only cost but schedule that the PUC has placed on Excel in relation to this project. So as we sit today in that schedule that I was just describing, we are at that point where we're not able to work linearly. We very much are overlapping, and so we have been negotiating land rights, for example, for the 2 years generally that was mentioned, yesterday, and are unable to reach agreement for whatever reason or any number of reasons. And there aren't conversations to be had with the landowners. We're just at a point where that information needs to be presented to a neutral third party. And that is what the condemnation process is. It's an opportunity for both parties to share information, explain their position, and share evidence. Landowners can get appraisals that we pay for. We provide appraisals, and that is presented in a hearing, in the case of a possession hearing, to a court. And a judge makes the decision based on the evidence presented to them. So really, when there's no further conversation to be had, we're just at an impasse. The next best step for everyone is to have that neutral third party involved and to hear that and make that decision. Ultimately, that timing as it relates to the permitting here in Elbert County and other jurisdictions is that we are acquiring land at the same time we're permitting for a number of reasons, that schedule that I mentioned. Also, when we get to trying to do other permitting that may follow land use permitting, we need those studies completed. Some of our materials can take many months, maybe even over a year, a couple of years in certain instances to get, so we have to have the design information ahead of time. And so it's not out of any sense of confidence one way or another about a permit application. It's actually a position the company has to take in terms of evaluating the schedule and acquiring land at the same time that we're permitting, and what that could shape up to be, that we're here in that place on the schedule in Elbert County. And it's very similar to other jurisdictions as well. I would say most projects, in fact, where we're conducting those activities at the same time. So wanted to touch on that relative to schedule. The condemnation process, to clarify how that looks. Generally, we start with negotiations with landowners. As mentioned yesterday, in the case of Pathway, we approached folks with the option to actually sign an option that had a wider corridor, a 500-foot wide corridor. We pay 25% of the potential easement price. That option gives us the ability to access properties, conduct studies, and then narrow it down to 150-foot easement generally that we would get. In some cases, we certainly had a number of folks sign those options to allow us to have that access to further refine that. In some cases, we did not have those signatures, and so we've continued to negotiate with folks to the point that we were no longer talking about the option, but talking about an easement specifically for that right-of-way, generally 150 feet. Those discussions and negotiations include terms of the easement, so what that easement says, what questions do folks have, what property-specific things may we need to consider to adjust that easement, as well as compensation. What is the price and the value to be paid on that easement? In the event that we're not able to reach agreement on either terms or value compensation, then we send an official notice, a notice of intent to acquire. That is part of that official process. It is a formal communication. It has information. It describes the landowner right to get an appraisal, the fact that we'll pay for it, under what state statutes the authority is provided, and then a schedule for responding to that. In the event that we don't hear back, or we do hear back with certain information, we send final offer letters as a next step in the process to indicate that we still aren't reaching agreement. That has the same and similar information. Sometimes it's revised information depending on the conversations with the landowners. And again, a schedule for response time on that. It is only after we've done those things over those months, and in this case of Pathway years, that we file condemnation cases. Those are cases filed in the district court. And there was some discussion yesterday about whether the numbers presented to the Planning Commission were correct. And the basis for that question was because of the timeline of some folks being served on those cases. So we file cases, and then those landowners are provided service of that case. That can take sometimes days, sometimes maybe a week or more for that to happen. So the numbers that I provided at the Planning Commission stand. We have filed 13 cases in Elbert County, and the 2 landowners, I think, that were mentioned last night that were recently served are part of that 13. That number hasn't changed and is the correct number. I think the last item that I'd like to address today is related to the completeness of the application and the fire district forms. We heard yesterday that we've attempted to get the forms. We heard from Big Sandy Fire District that they are willing to sign the form upon agreement on a number of items, and we believe that we'll get there with them. Last night I also spoke regarding potential conditions of approval that were in the staff report as a possibility. In addition to that list could be the condition of approval that we need to get those signed fire district forms prior to construction start in that particular district as one way to address that particular item. Ensure that the forms are obtained and allow us the time to continue to work with the fire districts to understand, address, and resolve their concerns. Do we have anything else? Checking with the team. I think that is all we had.
Okay, thank you. All right, at this time, I will take questions and comments from the Board of Commissioners. Commissioner Schroeder.
Thank you, Mr. Chair. I had the opportunity to take some time to generate quite a few questions here. First thing I'd like to do is ask our consultant if there was anything that she would like to add to our presentation.
Hello, good afternoon, Commissioners. There it is, okay. Sorry, third microphone of the event. Staff could respond to some of the additional information presented from the applicant in response to public comments last night, if desired. As far as specific questions, we are also here to respond to those. Was there anything specifically that you had in mind?
Yeah, anything in particular to the response to the public comment or public comment that you'd like to clarify or?
Sure. There's a few things. We were taking, all of us, copious notes during public comment. Also want to thank everyone for coming out yesterday. That was a real good turnout. And then thank you for coming again today. That's a lot of time to spend on a civil discourse and process and democratic decision-making process. I think that we heard a few things that could speak to that we did not necessarily put in the staff report related to some of the health concerns and EMF. The applicant did address some of those. There really is not a body of evidence at this time of peer-reviewed research that shows that there is a risk there. So that's one reason in our findings, we found that the EMF was not an issue. We also are thankful to the Excel team for having all of the experts and subject matter experts here, especially for wildfire. That has been a continued hot topic, and our understanding is that there are many ways to do fire modeling and risk modeling and assessment, and getting some clarity on the program from Excel has been beneficial, I think, for staff as well as members of the public, and some clarity on some of those additional materials submitted as part of the record. Elbert County has requested additional information on that topic several times to address that public safety concern, as well as some of the responses from the applicant during the completeness reviews was, for example, they manage that at the state level, and that is fine for them, and there's lots of information publicly available on the PUC website and out just in the world. However, in this decision on these applications, Land Use 101, if you want it considered, it needs to be part of the application, and so we needed that information to be part of the public record. I think that was really helpful to be included and to explain, as was explained yesterday, why there would not be cameras on poles. No one in this room except for Patrick is an expert in this space, and so and sharing the map that I hope now is part of the public record of locations of existing weather stations used and cameras that are available. That's very helpful to understand the situation there. I do think it could be helpful potentially if the commissioners would like to hear about some of those suggestions for conditions of approval and what the thinking was behind that, if you're amenable to walking through some of those suggestions that staff provided in the staff report.
I think it would be beneficial.
Okay. Could I get the puck so that I could share my screen here? There we go. Okay. Let's see. I might start with just, commissioners, as you all know, and I'm sure you're aware, and for the public record, conditions of approval for a permit application such as this and other types of large-scale, utility-scale, or smaller development projects are a common tool that local governments can use, and there's a few different reasons why they might want to do that. And one of them is, as the applicant has mentioned, it is accurate that projects such as this proposed project and projects at a utility scale, large complex projects, there are many, many, many people involved in it, and they're very complex. They're hard to do. There's a lot of schedules. There's a lot of moving parts, and the process does not necessarily line up perfectly with the project development and engineering process. So what you might have, the information at a planning stage, is going to be different than at a construction stage, or even, getting through 30%, 60%, 90% engineering design plans. So often, a conditions of approval list or process can help assuage needing all of the information at a point in time that just simply might not align with the engineering and financing of a project. That's true. And then there's also some compliance pieces that are a little different during construction versus operations and maintenance. And so these stipulations can be a way that the local government can try to sort of underline or double underline the big ticket items of this is what was discussed during the planning and land use permitting process, and this is the expectation of during construction and post-construction, and it's very clear, it's outlined, it's stipulated in the permit. That is also to hopefully enable the transmission of information, which can sometimes be lacking between the people involved at a planning stage and permitting, land use permitting stage, are usually totally different from the people who then manage construction or manage operations and maintenance. Information may not travel. So through those different teams, the applicant is similar to many applicants. They will hire a construction contractor to build the project. That construction contractor may or may not get a copy of the permit. They may never know anything about what the issues were in Elbert County in particular, what people are concerned about, what people care about. But a list of conditions is really clear. Here, this is what all the things that should happen and to be held accountable for. That also gives the county the ability, say there was something that for whatever reason, something was missed as far as compliance with state permits, federal permits, requirements, et cetera, then the county can point back to the permit and say, this was stipulated in the permit, and so we expect a correction of compliance within X number of days, or we're going to issue a stop work order, or what have you. because the expectation is very clear that, this is going to happen. That's very long-winded. However, just context for why local governments might want to do that. In this case, it's, the ultimate decision maker could potentially be a different entity from Elbert County. And so staff thought it was important to continue to share the priorities and perspective and interests of Elbert County going forward. And this was one way to maybe communicate that and for consideration. So starting from the top, and these were the same in the 1041 and the SUR staff report. The first one, just this applicant shall complete the required executed agreements. As staff mentioned yesterday, these could typically be a future date kind of item and that would be appropriate. It's often completed that way when there is a recommendation for approval with conditions. To our knowledge, and maybe this is a question for the legal team to ponder on, but I don't think there is a way to recommend denial with conditions. I think that would maybe be odd, but think about that. So it was just a signal to, there are still things to be done here and legal agreements. It sounds like the applicant is open to that, and just listing them was to try to provide clarity there. The item 2, this is from the Elbert County adopted resolution of development fees. This language comes directly from that, except for the timing stipulation, 6 months prior to start of construction. Sometimes it can be helpful to provide a timing clarification if you have conditions of approval, and that cost of construction statement is what is listed in that resolution that is used for the basis of the 2% assessment. The third one speaks to the development fees. I think that this was also addressed, at least to date, in the staff report with the the updated deposit from the applicant. This was simply, again, bringing notice to there would still be some things to wrap up after a decision is made. The D here is also from the resolution that was adopted. That's for the development fees, speaking specifically to the SUR. The fourth one, this was a attempt at just trying to continue to acknowledge the risks that can come from wildfire during construction, and in addition to the operations and maintenance. Arguably, and I'm not an expert, but it seems reasonable that the risk might be a little higher actually during construction with vehicles and the welding and all of those increased numbers of folks maybe traveling on roads and sparks that can come from vehicles, et cetera. So this was just it's probably a standard best practice, I would hope, for safety, but we don't know how all construction companies operate. And so this is just another check to ensure that, or try to ensure that safe practices would be used and employed by the construction contractor. For 5, demonstrating the alignment, it is staff's understanding that to date, the project-specific wildfire mitigation plan has always aligned and will align with the state mitigation plan. It was just a way to underline that, and it was written at a time when we were not, well, now I'm getting confused. I think it was already adopted. We were not sure exactly when the updated plan might get adopted by the PUC and if that would change anything related to this project. It sounds like maybe not, but it does also sound like there's still analysis that's happening for Elbert County that will be part of that updated plan This was just to, again, provide kind of an underline under the topic, and that the expectation there is that it does align and that we also understand that. The sixth one, this is just, the applicant has said this will occur, so it seemed like a non-issue to include it and just make sure that this would occur. The scheduled trainings for the fire districts prior to the start of construction that can serve a few purposes. One is relationship building, introductions, sharing of contact information, understanding who's operating in the area in the case, a worst case scenario of an event. The applicant, the number 7 here is calling for the applicant and the general contractor to submit a construction site safety and emergency action plan. The applicant said yesterday that they've provided a lot of the information. That's true, and it's a planning level of information. It's not a construction level detail of information, which is to be expected at this time. This is asking for more of a, when you get closer to construction, specifics, safety and emergency action plan, and in coordination with the general contractor, so that it's clear that the general contractor, that expectation is also there from Elbert County, and to try to make sure that the message gets passed along to that general contractor. The items here listed are pretty typical that are included if a company's doing best management practices for safety and site management. So it's nothing that staff saw as out of the ordinary. And we also we support construction compliance and understand that process, so didn't think that was anything out of the ordinary. The item number 8, this is also a pretty typical ask and requirement in linear construction projects and other linear construction projects to complete what we call pre-construction wildlife surveys or nest clearance surveys. It could be called at least 7 to 10 days prior to ground disturbance. And the reason is that while CPW and U.S. Fish and Wildlife Service, they have guidance and recommendations, they are guidance and recommendations only. And one way to take those recommendations and make them requirements and regulatory is a local county can make them part of the permit stipulations. And wildlife surveys, CPW, the applicant mentioned species-specific survey protocols. They do have those, and they mention them in the response letters. The thing about wildlife, though, is that they move. They don't stay in one spot. And so, in particular for nests and active nests, a typical best management practice is to either not construct during breeding season, which in Colorado is January to August, or do pre-construction active nest surveys before you blow through. So you're just checking if there's any active nests. If there's a biomonitor maybe is right before the construction crew, and doing a clearance survey. It's pretty typical. It's not, construction companies are doing it all over the state right now, actually, even. 9, the applicant and the general contractor shall employ biomonitors and cultural resource monitors during all construction activities. Again, this is a best practice, which maybe that's not the best word. Best practice means different things to different people. But, if there is a concern that there's any concern that, resources will not be avoided for whatever reason, which can occur. Having worked on construction sites, the priority is schedule and cost and managing 100 other challenges that can arise during construction. Having those monitors can help keep an eye on those resources to avoid impacts. The next one, number 10, speaking to permit authorized activities. This was pulled from the Colorado Parks and Wildlife letters that were provided. I think I have those up. There was the Northeast Region letter dated April 23rd, and then the Southeast Region letter dated April 10th. And they have their recommendations for avoidance in there. And the applicant is correct that the staff has not continued checking in with CPW, the referral, in part the referral agency period, and then timing from when it closed to getting response from the applicant to preparing for the Planning Commission hearing was very, very compressed. That schedule was very compressed. So the referral period ended May 22nd, and Elbert County received the responses from the applicant May 27th, and then the Planning Commission hearing was June 3rd. So no, there has not been time to follow up with CPW. We could certainly do that, but we do have, an attempt of trying to incorporate their recommendations into the conditions for the application. The rest of these are also straight, pulled from those letters and could be used to help avoid these resources. Burrowing owls have a special status in Colorado, swift fox as well, and it's really, especially during breeding season. So a lot of these avoidance measures are during breeding periods so that the young are not being negatively impacted. And so there can be some seasonal timings or buffers or construction restrictions on those. I won't go into details on those, but they're really just pulled from the CPW letters. The 15 speaks to the APLIC, Avian Power Line Interaction Committee. It sounds like the applicant is already a member, and this seemed like another non-issue stipulation. If they're doing this anyhow, it didn't seem like a problem to include it. If they're saying they follow these guidelines anyway and participate in that group. 16 also pulled from the CPW recommendations. 17 was simply doing, underline of make sure applicant and general contractor have completed the process with the county public works department of, if there's pre-construction photos and studies or analysis to happen that informs the road use agreement. And then, to document what, during construction, if there are impacts to roads, and if it was from construction activities, then coming up with a plan for construction or operations and maintenance, coming up for a plan for working together on how to address that. The 18 is speaking to the stormwater construction discharges during construction activities. Again, pretty standard. The applicant has said that they're going to do that anyway. It is a requirement in Colorado. This is just bringing awareness again and underlining it that the applicant and the general contractor will do that. If there were to be an issue, then this also allows for Elbert County to speak to it along with CDPHE. If there are, BMPs, erosion control, best management practice control measures like wattles and erosion control blankets or, whatever containment have not been maintained, then that gives Elbert County the opportunity to speak to that and point to the permit where it was a stipulation. For 19, this, again, is related to water quality and stormwater management. If there is, which it sounds like that's still an if, about the concrete batch plant in the TCA, concrete can be, and the washout from concrete can be pretty damaging to soil and water quality because of the pH. This would typically also be part of the stormwater management plan or the swamp that's part of the CDPHE general permit. It's just highlighting it again that the expectation is there that this is part of the permit compliance and expected to be complied with. 20, same thing, SPCC plan, pretty typical for a good construction contractor to be doing that, and it's going to be happen anyway. So, it's just in the permit because we want to make sure that is a copy can be provided if needed, or if anything did happen, that Elbert County did its due diligence to try to protect county interests and have that requirement and expectation really clear. 21 was so requiring the applicant with the general contractor responsible for decontamination of construction vehicles and equipment. This was directly from the comment from one of the planning commissioners, concern about cross-contamination from one site to another. That could occur, could be all sorts of things if there was something on one site, weeds or other species of vegetation you don't want on your property. In this case, it was a chicken waste, I think, and so maybe some concerns about some potential diseases or vectors that could be transferred. So having an expectation there of spraying off vehicles or using other methods that staff thought that might be beneficial for consideration. And then 22, the applicant with the general contractor should inform the fire districts and Elbert County of construction schedules and locations and provide 3 months updates every 3 months. That's just acknowledging again that those construction schedules are not that fleshed out right now at this point in time, which they usually are not. But that as you get closer to construction, that Elbert County remains in awareness and then could even potentially work with the general contractor to provide those updates to the public. For example, we're working on this segment now, or, the roads, this is where construction vehicles might be on the roads during this time, or this road might be closed, et cetera. So just communication and awareness of what's going on and where. And then 23, the applicant with the general contractor shall obtain a welding permit. That was something from the Big Sandy Fire Protection District, and just wanting to make sure that that was highlighted and understood and communicated to the general contractor that this is going to be a requirement, and please coordinate with them on that prior to construction start. Have any meetings that need to happen to understand workflow or decision points in that process. And then the last one is, again, a pretty straightforward and should be understood, but never hurts to put it in, the stipulations that the project will comply with all applicable local, state, and federal laws during construction activities, as well as operations and maintenance. And again, that helps represent Elbert County interest if there were to be a worst case scenario, and some state agency or something says well, this wasn't in compliance here, and then Elbert County can say, oh well, we heard that this isn't in compliance, or we talked to so and so, and now we want to know how it's going to be corrected. This is Elbert County, we care about our county. And now you have something to directly point to say, we do have a say here because we have a permit and it's in the permit. And we're hearing from whatever state group that it's not meeting the requirements. That's all. That was a lot, but hopefully that was helpful.
No, I appreciate that. Thank you for the information. I do have a series of questions for the applicant. And I'll just start off by saying some of these are going to be pretty direct and pointed. Please don't take them personally. I understand you have a job to do, as do I, but we need to get to the bottom of some of these questions and see where we end up here. To begin with, the first ones that I will go through probably just fall under the category of other concerns, and just need some more information about it. First of all, we heard yesterday many times about private property rights and how important it is to our citizens, and I certainly agree with that. I'm sympathetic to that private property rights. You made a comment earlier that it was only after an impasse that condemnation action would take place. How many, remind me, how many back and forths there are before it's considered an impasse?
Sure. I wouldn't say that there's a specific number. We hit 2 and we're done, or 4 and we're done. Really, I think over the months and years, you start to get to a point where maybe we've had 20 conversations, 10 meetings, 50 conversations, 5 conversations even. It depends on the specific situation, and there's no movement in either way. There's a term that can't be agreed on. There's a dollar that can't be agreed on. And if at that point, the answer is we don't agree and we can't reach agreement, then we would move to condemnation. But when we think that there is, and the landowner has potentially expressed an interest in continuing negotiations, we'll try to do that for as long as we can. That's part of the reason that we don't have our land acquired, for example, before we come in for a permit. And that's also why we ask for jurisdictions to be aware that we want to continue negotiations as long as we can through the permitting process, and even prior to and during that process. So I think that they're, in the case of landowners in Elbert County and consistent with other projects we have too, sometimes we're just not going to get there. And I think that landowners and our land agents would acknowledge that in many cases, that we weren't getting there and we should move on. Condemnation, again, provides an opportunity for them to get the information at our cost, things like appraisals. Go get an appraisal. If the issue is dollars, then let's talk about the dollars and get the appraisal. We'll pay for it, and then we'll take that to the third party and see where we land.
Okay. You addressed this earlier, but it certainly feels like the cart was put before the horse. And I understand your explanation for the timing, but to start these condemnation issues before even coming to this board for an up or down certainly gets the feel of an entitlement, and we're going to do what we want to do. Doesn't matter what happens at this hearing. And I will certainly be in contact with both Senator Rod Pelton and Representative Chris Richardson and see if there's something legislatively that can be done to this, because it just feels wrong, and it puts the landowner at a disadvantage in their negotiations when it hasn't even been satisfied here. I guess my concern with the condemnation and eminent domain is that, in my opinion, those issues should only be under emergency situations and when there is absolutely no other option available. And as I look at the map, the proposed route hugs the western side of the study area. If you look out throughout the even farther west, there's some more areas that would be less populated, less impactful to our citizens. And so I feel that there's just been a desire of pushing a specific route and not really listening to our citizens. And I guess that's more of a comment than a question. But the private property aspect of this really is bothering to me. The other issue that I have here, a question, is as far as the siting of specific poll locations and the route itself. Last Wednesday, I took all afternoon. I drove the route to get an eyeball on where this was going to go, and several things popped out at me as I went through the route. One was on our packet. I don't believe we had anything that had specifics on pole locations. Is that correct?
I guess, would county staff want to speak to the packet or what was provided in the we had detailed drawings in our application that outlined the pole locations and access, but perhaps staff wants to address the packet information?
Yes, there are the pole locations, I believe, were added to the site plan exhibit, as well as attachment R. They're in,
Okay.
I could work on pulling those up. If
That's fine. I apologize for missing it and bringing something up, but yesterday we had a public comment from someone who said they didn't know if there would be a pole on their property or not, or if it would be overhead on a corner of their property, and so it just made me wonder if are we still kind of squishy on where the poles are going, or are we pretty firm where they are?
No, generally we're pretty firm with where they are. There's still potentially some micrositing on properties that we haven't maybe been able to access to shift them in minimal amounts, I would say. I think there is some maybe confusion in certain instances where we do cross a property aerially. We don't have a pole on that property. And so in that case, we still obtain an easement. Same for the other properties. Because we may need ground access for construction or other things. So we don't have just an aerial easement that says there's wires there. It allows the ground access. And so in those instances, I think that could be confusing. I believe that we have communicated with the landowners where that's the situation. But again, I think sometimes it's just confusing because the easement form is the same.
Okay, thank you for that. As I drove, particularly on Highway 86, as I understand it, this project is to bring renewable resources of electricity to the metro area, and it's a green energy project. But yet it looks like in several instances, particularly along the Bijou Basin, there's going to be extensive trees that will be cut down if it's within the easement. I believe one of the citizen comments yesterday said as many as 100 trees. These are trees are special in Elbert County. We don't have a lot of them, and we kind of like them. And so I just would curious if that went into the decision making of trying to reconcile a green energy project with cutting down hundreds of trees along our most scenic areas.
Sure. Certainly, we look at land use types. Is it grassland? Is it treed? Is it forested? As part of what we map and evaluate. As we looked at the areas where we were going through treed areas, you mentioned along Highway 86 as an example, we attempted to co-locate that along roads, for example, or other features like transmission lines where there's already been some tree clearing. And so it's an incremental change or an incremental additional clearing in those cases versus call it a greenfield route for lack of a different word. If we were along Highway 86, as I mentioned yesterday, we do overlap the CDOT right-of-way with our easement in a way. So what might be 150 feet, if we were to go midfield, might be 110 feet easement because we're sharing some of that with CDOT right-of-way. In that way, the portion of the easement that's towards CDOT where there's already clearing, that's not clearing we would have to do, so we incrementally have to clear less when we co-locate along the highway like that, versus if we were to go through that treed area away from the highway right away, it would be 150 feet of tree clearing. So we do take that into consideration in decisions to co-locate adjacent to roadways, to avoid large forested areas where we can in a greenfield scenario.
There also seems to be many houses along the highway 86 there on the south side that appear to be in the easement or very close to the easement. Do you still have a distance that you try to achieve to keep poles away from buildings?
So, as mentioned yesterday, we don't allow buildings in the easement. That includes homes. Occupied buildings in particular aren't allowed in our easement. We placed the easement for the entirety of pathway such that that wouldn't happen. There were no homes in the easement. There are no homes in the easement. We did not tear down people's homes or force them to leave. That's true here in Elbert County as well. Beyond that easement, we don't control the land, and so in the event that there's a home closer or farther away that exists today, that's not something that's dictated by our easement and the placement of the line. We acquire the easement that's needed for safety and clearance requirements. The same is true if our line is there, that people can choose to build their homes as close to our easement as they elect to do, and we see that a lot where people build up closer. So we don't restrict outside the easement. That remains under the control of the landowner. So beyond that, no, we don't have a set number where a home can exist.
Okay, I believe we heard from public comment yesterday that they believe that a pole would be within 37 feet of their home. Would that is possible? If it was on the edge of the easement?
So our easement, if we assume our easement is 150 foot wide, 75 feet on either side of center, that would mean that there would be no home within at least 75 feet of a pole. Could it be 75 feet plus 30, 40, 50 feet?
Okay.
Yes, that would be possible if that's what was indicated.
Okay, thank you for that clarification. Just as a reminder, how long did we first start this process, the first pre-application meeting?
The official pre-application meeting was in 2023. We met with the county prior to that, beginning in 2021, unofficially.
Unofficially? So I would assume by 2021, though, you were already looking at our regulations and those type things getting ready to go. So I'm a little concerned, and explain to me how it has taken so long to get to this point. We were really expecting this application to come last summer, and even with all this time for staff and our consultant to still find the application incomplete, if you can reconcile that in my mind, I would appreciate it.
Sure. I think that as noted, the applications, there's a lot of pages, there's a lot of information, and part of the discussion with county staff was about the level of detail that would be provided in the application. Things like the pole locations and our temporary construction areas, pool sites, access roads, so on. That takes a long time to compile. We were continuing to work with landowners to gain access to property, to conduct survey, whether that be wildlife-related, wetland, or design-related survey, to inform that so that we could get to locations and information that we didn't anticipate was significantly going to shift. So it took a good deal of time to do all of that, to present it in the application relative to design, not only here in Elbert County, but again, we designed kind of the segment as a whole. So, over 100 miles of work went into that to then present the portion here in Elbert County. And in terms of the completeness, what I understand has been deemed incomplete by the county is related to the fire district forms. We have been working with the fire districts to try and get those forms signed. We weren't able to get those forms signed, and so that's why we elected to move forward, because we didn't have them and we weren't getting indication at the time that they weren't going to be signed. We can't make anyone sign them, and wanted to present the information to the county to have that reviewed, and also, as you said, to move the process forward, right? There was an expectation this was going to be maybe provided sooner, and how much longer would we wait? The community is anxious to get to resolution on this, and we also still need to get, things move forward for the project schedule and the in-service dates relative to the requirements the PUC's placed on the project.
Okay, so to follow up on that, the representative from Big Sandy Fire yesterday mentioned that their first contact with Excel was April of this year. So it seems like, that was one thing that should have been done sooner if this is a long-term project and you know that this is a requirement for a complete packet. I'm just having a hard time reconciling the not getting these details taken care of.
Yeah, we did outreach to the fire districts before April. I understand as volunteer fire departments, perhaps communications don't make it to the right people, or they, in the day-to-day, aren't maybe captured, but we did communicate prior to April.
Okay. In July of 2018, the commissioners at the time put a proclamation down, and it was mentioned yesterday by public comment, and so I got a copy of it, and it's Elbert County Right to Farm. I'm not sure that you would be familiar with this, but there's two key provisions in this proclamation that I think apply to this application that create some questions and concerns for me. The fifth whereas in here, it says, whereas farmers and ranchers in the county have a right to pursue the best management practices most ideally suited to their operation. And so you can see that the desire is to let farmers and ranchers make the best decisions for their property and then suited for their operation. And this kind of goes back then to what is allowed on the easement, and if we could have another discussion on the fences and how that applies. As I took my drive around the county following the line last week, it appears as though many of the lines follow existing fence lines and or section lines. And so I understand particularly those places in a more rural setting, it probably is not such a big issue. But those closer in and on smaller acreages, it certainly could have a impact on them. So just refresh me on that conversation on fences and what's allowed and what's not.
Sure, have to push the button appropriately there. And Parker can come over if he feels like I'm misstating anything from an engineering perspective. So the easement speaks to things not being allowed in the easement that interfere with the operation of the transmission line. It does mention such as fences as a kind of for example. In the case of fences, when fences exist on a property, when we put a line in, we do not require anyone to remove their fence. We design for that fence to be there, and that includes sometimes providing gates between field fences so that we can travel down line in coordination with the landowners, adding fences or access off a county road in order to get to the line. And so we don't require people to remove fences. We design for them. In the event that a landowner would like to erect a fence in the future for whatever reason, or corral a fence and so on, there are certain kind of height considerations. We just want to make sure, again, if they were putting in a very giant fence, trying to think what that would be, above 14, 15 feet tall is where we get into a situation. A typical field fence, or I think up to 8 or 9 feet even, we just say that's generally allowable. We just want to make sure that, again, it's not creating an unsafe condition by bringing something too close to the line.
Okay, thank you. There's also another whereas clause in our Right to Farm proclamation that says, whereas for any reason an entity takes action which results in the decrease of value of property and or community production, the entity causing the loss should be required to compensate the owner of the damaged property an amount equal to the value that would have been realized from routine harvest had the land use remained as the owner had planned. And so I'm wondering if that was contemplated with any of the offers that made for the easements in the loss of production, whether it be hay production, cattle production, whatever the case may be, that could be a reoccurring loss for the landowner.
Yeah, maybe I'll touch on that in two different ways. In the event that there is crop damage during construction, for example, if crops are planted and we drive down the line for construction, we pay crop damages to that landowner, not only for that crop year, but we assume prior crop years as the soil maybe needs to be decompacted over time. So we pay crop damages in that way. When we look at compensation on the property and the use and what may or may not be the change in use, once construction is completed, folks can continue to use the area in the easement for ranching, grazing, and even crop production. In the event that we come through to do maintenance in the future, and again, if there were crop damages, we would compensate for those. As we look at the value of the easement that we place, the value for the easements that we pay nearly full price for that acreage. 95% to 100% was mentioned yesterday of the fair market value of that acreage. And so we are also paying for that use, our use as the transmission easement, and understanding what limitations that may place on the use, such as not being able to build structures or whatever.
So along those lines then, I know the packet, the assertion is that fire risk is slight or moderate, depending on the area of the map that was shown yesterday. In the event that there was a fire that took out crops or cattle, whatever, is there compensation built into your contracts for that?
I think that compensation there would be handled by kind of what we're obligated to do by law. Our easements, and I'm looking at Julie, don't say anything specifically about fire damage that I'm aware of.
Okay. There's been a lot of talk at the national level on funding and for green energy projects. How is Excel funding this, and are you receiving federal dollars or grants or credits in line with this project? And do you feel that those dollars might be in jeopardy due to the cuts being made in Washington?
Yeah, I can answer that. I'm Heather Brickey. There are no federal funds that are allocated to the Colorado's Power Pathway Transmission Project, so there's no risk of losing any funding. This is purely a company-funded project.
Okay, thank you. There was a long discussion on property values, and it's just a comment more than a question. I think even if the property value itself doesn't go down, you certainly are losing potential purchasers to have a pole, particularly on a smaller acreage with a home. And I'll just speak from experience. About 10 years ago, my family and I were looking at purchasing a home, and I went out on the back porch of that home to take one last look around and heard a screech. And I was concerned about that, so my daughter and I walked over the hill to look, and there was a prairie dog town there, and that did it for me. No matter how much I liked the house, no matter how much I thought that would be a good place for my family, simply because of certain outside forces, realized that was not a place I wanted to be. And so I think that could still be a concern for people, particularly on smaller acreages. I myself live on a 5-acre parcel. I can't imagine having a pole on my middle of my 5 acres. So I do think that that does reduce the amount of the pool of people who would be interested in purchasing a product when we go onto a smaller acreage. The wind rating on these poles and lines, if I remember right, around 90, 95 miles an hour.
Yeah, I'm gonna ask Parker to talk about design considerations.
Yeah, hi, Parker Rozak, Transmission Line Engineering Manager. Yeah, so the National Electric Safety Code, one of the loading requirements is for this area is 95 mile per hour, 3-second gust response.
Okay. And with all the weather stations, or I guess there was 2 of them, if I remember the map correctly, that's monitoring the weather. If we're approaching a high wind event, is electricity coming through these power lines rerouted for safety concerns, or are they still just pumping electricity and hope we don't hit 100 miles an hour?
The electricity is not shut off, no. Not, I mean, we do have PSPS events. I'm sure you saw that in the news. Generally, those are on distribution circuits. We do have wildfire safety settings where reclosing will be turned off. So if there is a line fault, it won't try to re-energize. But outside of a PSPS event, which is communicated to the communities, we don't proactively turn transmission lines off.
And so tornadoes, high wind events, other types of storms, there's to me, it seems to be the risk of that would be an issue. Do you have any knowledge of a tornado going through where a transmission line is and what the result was?
Yeah, so the way codes work is they're based on mean return intervals, so how frequently a storm can happen, basically, right? And so different facilities are designed for different mean return intervals. So, for example, transmission lines are designed for a 300-year mean return interval. A hospital is designed for a 3,000-year mean return interval because you really don't want a hospital to have a failure, right? So the way that the Society of Civil Engineers and electrical engineers and state governments and things like that have adopted the codes, put them in place to take basically risk into account. So there is risk, right? Weather events can exceed what they're designed for. So you could get a large, hurricane on the coast, for example, right? When you get a Cat 5 hurricane, there's a lot of damage versus a Cat 1 hurricane, for example. So can damage happen from tornadoes? Yes, that does happen. You see it predominantly in the Tornado Alley, for example. I'm sure people have seen pictures of large amount of damage to homes and power lines and things like that. So can it happen? Yes, it can happen. There is risk involved, but we do follow the codes, and the structure is designed to withstand most weather events that you'd expect to see. And if there's weather events outside of what the codes require, there is a potential for failure. Generally, I would say on our steel structures and our modern transmission lines, we rarely see that type of event. We had a tornado a couple of 4th of Julys ago out on the eastern plains that a bunch of wood structures had failed. But the steel 345 lines sitting literally 100 feet away just stood there without a problem. So, we do the best we can to make sure that we take all that into account when we do our designs. And maybe I could touch on how the structures are designed too. So there is excess capacity. We don't design to 95. I mean, when we do our design loading, it is 95 mile per hour wind. There's also a bunch of other load cases that we design for to account for ice loading, wind and ice loading, things like that. We design a family of structures, so they're designed for a certain span length. So we say the average span length is 950 feet for the project. So that means some spans will be 700, 800 feet. Some spans might be 1,100 feet, just depending on topography. So if you take these structures, they're designed for a 1,200-foot span. So when you apply the 95 mile per hour wind, you're applying that to the entire length, perpendicular, all at the same time. And so the loading cases are trying to put into like a worst case scenario. So I guess to sum it up, tornadoes do cause damage. It does happen. We do try to, follow the codes and have our own standards that exceed the codes in many cases. And, when there's a problem, we, then go out and fix it.
Thank you. That pretty much concludes the questions I have. But I do want to tell you and relate that I do have some serious concerns about the application. There's been a lot of discussion on the fire prevention and safety forms from the 2 fire districts not being completed, as well as a discussion with the Natural Resources Conservation Services on the Wetland Reserve Program easement. I know this property. When I drive by it, I always pay attention to it. I am a waterfowl hunter, and so I'm familiar with the animals and the birds and the ducks and the geese that visit that place. And so I'm concerned that is not completed as well. And so those 3 documents, if we were to approve without having these documents and saying that it is complete, in a sense, cedes our authority and decision-making, final decision-making, to a third-party entity, which perhaps they would like that, perhaps they would not, but I don't think it is fair to put that burden on a third-party entity in the terms of a condition of approval. Likewise, not having a road use agreement or a development agreement is concerning as well. We have in the past done situations like this where it was on a condition of approval, but we're trying to get away from it because our staff has relayed to us that it puts them in a disagreement or a disadvantage in discussions and in consultations, trying to negotiate the best deal for the county when the commissioners have already approved something, and that based on the road use agreement or development agreement still has to be done. So that is concerning to me as well, and I will end for now with that, Mr. Chair.
All right, thank you. So we're going to take a 10-minute recess. Be back in 10 minutes. Thank you. Okay, Commissioner Buck, I'll turn it over to you, sir.
Okay, thank you. I'm just going to start where Mr. Commissioner Schroeder left off with the property values and the location of a pole as it relates to the proximity to a home. So we talked a little bit about that. So potentially a pole can be within 75 feet of a residence.
Potentially like the corner of a residence, that
Yeah.
is technically possible, whether it was built after the line was there. As we measure it today, based on the placement of the line that we have designed in Elbert County, the closest corner or the closest point on a home is 163 feet away.
From where you're currently...
From the edge of the easement, yeah. Center of
Okay.
the easement, sorry, center of our easement, yeah. So that would, 163 feet minus 75 would put it 90, 87, whatever the math is, feet away from the edge of our easement.
So 80 feet, potentially 90 feet from a home.
From the easement. The
From the
pole,
e- from the edge
pole
of the
itself
easement, I
would be
gotcha.
163 feet away.
So a 150-foot pole. My concern is the value. The appraiser that you presented to us yesterday said there was no perceived value reduction in his market analysis. Now, I know a little bit about real estate, and I know for a fact I would have a huge discount if I was going to buy something with a 150-foot pole that close to it. And I would expect it, and that's how they sell them. Nobody just looks the other way and pays full price for one with a 150-foot pole on the appraisal documents that you gave us of comps from Early and Associates, it's dated. It's dated from 2022. It is residential subdivisions, which is not what we're talking about. And the conclusion is, I do not find any appreciable market impact on residential property values or appreciation rates attributed to high voltage transmission lines. I do not believe this at all. And if I need to apologize in advance for my tone or my attitude or my bluntness, I can do that. But I think this is disingenuous, and I'm actually a little insulted by this document that you gave us. Why would we do an appraisal or provide this to us on residential subdivisions from 3 years ago? Why is this being presented to us?
Happy to have folks speak to why that particular study. I think that was prefaced a little bit yesterday. Do we want to have Bob answer that question about the study being 3 years old, residential subdivisions described in it, and so on? We'll swap out a seat here at the end, perhaps.
Good afternoon, Rob Wells again. I think the study was done in 2022. That was kind of the beginning of the project here. It is local in Colorado. Other specific?
Well, it's residential subdivisions. You're comparing apples to oranges. I used to work for a mortgage bank. I've been in real estate since 1989, and I know for a fact that a large transmission line will significantly degrade the value of that property. So I would like to know where you're getting your information and what analysis you've done, because this one that you proposed, did you provide this to us? Was that the one you gave us?
I did not do this study. I think our team, somebody handed it to you, but I did not do this. This is a Mike Early study. So we could put up the other graph with the 3 studies. Do we have that? We don't have that.
Are we able to provide a graph to you all as an exhibit or hand it out hard copy?
I actually don't need to see a graph. I think we all know, everybody in the room knows, and I think we're fooling ourselves if we're going to say that it doesn't devalue the land.
Yeah, this is an example of 3 rural, non-urban property studies that we were able to find, none of which are in Colorado, unfortunately. We weren't able to find one that would fit within Colorado, but there's studies from other areas of the country, the Midwest and Texas, and they show a variety of indications. They each have their own idiosyncrasies, but one, to give you a short version, one is a little bit positive, one is a little bit negative, and one is at kind of 0. So the midpoint is kind of a 0 impact that an appraiser could make, and I see an appraiser has joined us here, but an appraiser could make for properties that would be off the easement itself. So we're not talking about subject properties where the easement crosses, but those are the off-property easements. They tend to decline very much so in a distance situation. One of them, a study done, found no clear impact on proximity lots. Those are outside of the touching the actual easement, within 200 feet of the easement. There are other studies that also have measurements in. Almost all of them find anything over 1,000 feet. There's no impact whatsoever. Not discernible in a study. Happy to get into more detail on the studies, but if you have any other questions.
Commissioners, Lance Ingalls, County Attorney. I've been offered a graph from the applicants in this case. If I mark this as an exhibit and put it in the record, it will be Exhibit 5, but it's a question for the board. Public testimony was closed. After public testimony was closed, you did receive Exhibit 4, which is the study you're currently talking about. This would be Exhibit 5. It's within the discretion of the board to accept this or not, but the public was not able to talk about either Exhibit 4 or this proposed Exhibit 5. You have the option to accept it or not. You have the option to reopen public testimony on these issues if you wish. And there's a lot of options available to you, but I can't make this decision on my own.
I really don't think it, since it's closed, I really don't think that it's closed. We don't need it this time.
Okay, let's continue. My next question, and you guys addressed it, and you did a decent job of addressing it, but I want to clarify a little bit more on the scheduling and the perception of how that all worked. Can you give me an update on how many landowners you have already acquired easements from out of the total? I have 40, is 47 the number, total landowners?
Looking for the latest data. Matt, number, please.
We show the number of landowners is 48. We have acquired 25 of those landowners.
So what is the typical percentage for eminent domain filings versus a landowner negotiated agreement for a project of this type?
Oh, typical number. It really varies depending on the project and what we're doing. For Pathway, if I were to look and think about other segments, for example, the 13 cases that we've filed here is a very similar number to those filed in certain other counties along other portions of Pathway.
So you think, so we're at about 27%?
I think the number is actually
13
of the
out of 48, roughly 27%. You're filing condemnation proceedings.
in terms of the percent acquired, Matt. I think on miles it's 30 something. I mean, it depends on whether we're talking about landowners or miles.
Out of the total number of landowners, if you're filing against 13 of them, so far,
Yep,
you're running about 27%.
sure.
So my question is that a typical number
We
for this type of project?
At certain stages, yes, I would say it's typical. We see sometimes additional signatures after permitting process. We sometimes see signatures early on. We see signatures along the way. There's nothing to say that that remaining percentage couldn't sign tomorrow or the day after or a week from now. So it's not atypical to not be at 100% at this point in the project.
No, I don't doubt that. I was just wondering if you feel you are offering just compensation, and the numbers sounded high to me at this point. Mm-hmm. And are you paying fair market value or assessed values and basing that your payment from those numbers?
So generally, we offer fair market value for the properties. We do share with landowners as part of the negotiations what the appraised value would be.
What the appraised value would be or the assessed value?
Appraised.
So you guys are familiar with our 1041 and SUR guidelines, correct?
That's correct.
Do you guys think our guidelines are reasonable?
I'm not sure how I would define or reasonable. I think there are many things that are similar to other jurisdictions, and I think there are some things different than other jurisdictions.
Okay. I just wanted to see what your thoughts are, if you thought they were extraordinary or if you thought they were, too restrictive, or just what your opinion might be on our guidelines, or if you thought they were reasonable considering the type of project?
I think, again, there are things that within the guidelines that are different than other jurisdictions that we don't see. If that's a measure of different or reasonableness, I don't know how to categorize that.
That's fine.
That's
fine. What I'm trying to do is I'm just trying to understand the process, because there was a lot of confusion about the order where the applicant can obtain and will obtain all necessary property rights and easements. In Article 17 M1A, our guidelines state prior to site disturbance, not prior to a hearing. So you guys talked about scheduling and linear scheduling and different things. So you did kind of explain that, but you can kind of see where the perception was that you guys were just checking a box. It's already been determined. That's why they've already gone out and they're ahead of themselves and they're out of sequence. So that's where you heard yesterday people were concerned that you guys are checking a box and nothing could be done about the route, and it was all predetermined. And that's why you were out in front of yourselves or with the citizens, condemning property and acquiring those rights. So you can kind of see where that would happen. I'm going to read a letter that was in our packet, just a quick paragraph from it, from one of our citizens. It says, Excel has asked that I reach out to all landowners who have not been able to reach an agreement with yet, and let them know that the route as depicted in the attached exhibits will not be changing at this time. If a reroute discussion needs to occur as it relates to routing in a different location on your parcels, Excel is still open to discussions as it relates to this, but the route itself will not be relocated onto another parcel. Please let me know if you would like to continue negotiations as it relates to Excel's request for a permanent easement, or if you would prefer to transfer your negotiations on this matter with Excel's attorney instead. So you're telling people it's not going to change. You went to the community meetings and you told people it's not going to change. I would like to see written documentation if you have, that you listened and changed anything from public comments at your open house or any of your open houses, if you have any documentation in that regard. Because to be honest with you, I personally had a phone call from one of your lobbyists, and they told me we can't do anything about it. The routes can't be changed, and it was all kind of a done deal. So I personally received that phone call. Now,
Sorry, did you want me to address anything there?
You certainly can.
Is that okay? So in terms of written documentation about what was adjusted or changed based on public feedback, I'd refer to our routing study, and if we wanted to bring up the attachment to the routing study, it goes, link by link is a terminology, just a link is a part of the spider web of options where it connected to another. In the appendix attachment to that routing study, it goes link by link. This was changed because this was modified based on comment. This was removed because, so we have included that in the routing study. Specifically, I can say I was and have been involved in the project from the beginning. I participated in every single public meeting associated with the project and the routing study myself. Literally didn't miss a one around the entire state of Colorado, including those in segment 5. We did not have a predetermined route as part of that process when we started. There absolutely was not a route handed to me, handed to the team at the beginning that this is the route. That route and the application was determined through that process. I understand that folks have opinions that it doesn't belong here or shouldn't be here, and that it should be somewhere else. And the people that live somewhere else say it should also be somewhere else. And so what we're trying to do and did do in the routing study was balance a number of things. And again, I understand that folks may not prefer it to be here.
But these citizens testified yesterday that they were told in these open houses that there's nothing you can do about it. They were told by your executives that this is the route, there's nothing you can say that's going to change it, and that's how it's going to be. And I even received one of those phone calls. So how do you explain that?
Sure.
Let's talk about your routing study real quick, since you brought it up. The routing and siting study, winter of 2022. Among the links eliminated were links 5104 and 523. Link 5104 was eliminated because of its proximity to residences and an Elbert County priority economic development area. And link 523 was eliminated because of its proximity to residences.
Mm-hmm.
But then you went and just moved it. You eliminated that line and moved it to somewhere else within our, so it didn't make any sense to me when I saw that. You
Sure.
moved it to somewhere else along the same economic development area.
Yeah, if I could, I think there were kind of 2 points there that I could address in terms of what executives said at a community meeting. The timing of that community meeting was a year ago, in June of 2024. At that point in time, the route had been selected. The routing study was concluded. We had announced the proposed route at the end of 2022, thus the date on that study. And from that point forward, we were discussing with landowners, doing our design, prepping permit applications. So at that point, the route was not shifting to other properties. We were willing, as noted in the letter that you read, to microsite with landowners on their property. So for example, having conversations about how many poles we suggest on the property based on the technical design criteria, and would it be helpful in any way to shift it this way or that way? For example, maybe a landowner says, I think that pole might be too close to my driveway. Could you move it further away? And where we can accommodate that. So we were working with landowners on their properties, but we were not generally shifting to others at that point in the process.
So what you're saying is today's discussion, and as far as the board here is concerned, we don't have anything to talk about in regards to the route. Because that's what I'm hearing. It's already been decided. You just said that, and there's no changes going to be made.
What we've proposed.
Because I had a whole bunch of questions in regards to different routes and different things that we can just skip over to save time if that's not something you guys are willing to discuss.
I think just trying to understand, I'm always happy to entertain the discussion and help explain the process. We have an application that's been presented to the county that has a route in it. So to the extent that the application has that route in it, that's what we've presented to the county. If the discussion is about a different route, that wouldn't be evaluated in our application, and I'd have to look at county staff to understand what an attorney, how they wanted to handle that.
Okay, fair enough. Fair enough. I appreciate that. Because one of my major concerns, I'm not going to talk about some of the different routes.
Again, happy to explain the what's and whys to the best I can, just so if it helps inform people why.
One of my main concerns with the route that you chose was 3 or 4 years ago, that was primarily ag land, right? And it still primarily is. Part of the route that you chose is in our economic development zone, and it is been rezoned for a PUD, a couple of PUDs out there. And my concern is, I have a huge concern for the citizen of an individual landowner that may be losing $100,000, $200,000, whatever it is in land value or more, but the land value in general along the corridor of an economic development zone is not $100,000. It's not $500,000. It's millions and millions of dollars in lost revenue for the county and development opportunity. That's a big stretch of our economic development zone. And I don't see anywhere where we are getting compensated for the amount that is going to be negatively impacted. Those homes, I think the developer, I'm surprised the developer's not here. They're the ones that is going to be impacted the most. His homes are going to sell at a discount because they're going to be looking right at a power line. I'm very surprised they're not here today. And with the decrease in value, I feel there's a decrease in value. Your appraiser does not, so we'll agree to disagree on that. Has there been any study done on county tax assessed values and what that might do to lost revenue for the county, and what Excel has done to mitigate that potential loss in tax revenue?
Specific to property values, I assume that question is.
Yes, correct.
I have not done that myself, so looking to see if we have anyone who wants to address that otherwise. Julie. Okay, so sounds like our appraiser.
Yeah.
David, if you want to introduce yourself.
I'll just give a brief introduction on myself. My name's David Bethel. I'm a real estate appraiser, just a background. I got a finance degree from after college. I went to work for the appraisal firm I'm still with today. So I'm a real estate appraiser, been appraising for over 26 years, specialize in right-of-way projects throughout the nation. I'm certified in over probably around a dozen states. Appraised all different type properties, and I hold the MAI designation. And so I can give I think it would be helpful if I just give a broad overview of like the appraisal process that I have to go through to determine just compensation. If you think that'll be helpful for you.
It might be helpful for the audience. My nephew used to own one of the largest appraisal firms in Colorado.
Okay.
And like I said, I used to be a mortgage banker, so I'm very familiar with the process and how appraisals work. But if anyone else would like to learn about appraisals today, they could raise their hands maybe. I don't think anybody's interested.
Okay. Well, with respect to the question on assessed values, I've done power line projects in multiple states. I've never seen a particular county apply discounts for properties with power line encumbrance. That's not to say that your county here won't apply a discount, but I have not.
No, I don't think they would apply a discount either. I 100% agree with you.
Okay.
But the property value will decline, and they will have to assess it. When they sell, it'll sell for less, and then it'll affect the comps, and it'll affect that particular property, and they will be taxed at a lower rate.
Well, with respect to that, there's been some studies that I think were produced, but when I go to do appraisals for a project, and I've done it multiple times, multiple states, and here we're talking about agricultural, rural residential land. So the data that I look at to assess the impact, whether or not there's an impact to the land outside the easement, is I look at agricultural or rural residential properties that have encumbrances of power lines, and I compare them to similar properties without the encumbrances. I've done it throughout the surrounding counties and here in Elbert County, and I've studied basically acreage properties. Most of them are 35 acres and greater, and the indication, and it's consistent with the state of Texas, it's consistent with Missouri, Illinois, New Mexico, Oklahoma, is that any impact on the property value is contained within the easement area, and it doesn't go beyond the easement area.
150 feet?
That's correct, yes, sir.
Really?
Yes, sir.
How far away are your comps?
Well, there's some in Elbert County, and the are we talking about the comps to value the subject or these
No,
paired
when
cells?
you're doing some of your appraisal work and you're looking at these values, how far away are the comps that you're using?
For the paired cells analysis?
Yeah.
There's some in the southwest portion. I've got to go where existing power lines are to study them. So we've studied them here in Elbert County in the southwest portion of the county, done several studies in Arapahoe County, Adams County, Washington, and Pueblo.
No, I'm speaking of a specific 2 miles, 1 mile from those power lines. When you pull a property
Yes.
to look at, you analyze the value based on the acreage, the square footage.
Typically the price per acre, yes, sir.
Yeah, and then what's the bedroom count, bathroom count, all of the details of the property. Then you have to go find a comp to compare
That's
it
correct.
to compare it to. So I'm asking you, when you do those studies, how far away are your comps?
In some instances, the comps are multiple, like the encumbered, you have an encumbered property, and we compare that to other properties that are multiple miles away. In some instances, we compare them to properties that are closer, but not encumbered. So the property with the power line is what we're comparing to the other properties. Some of those properties are a fair distance away, which have no view of the existing power lines, and others would have a view, but they don't share the encumbrance. And these are all acreage properties.
Okay, good. I appreciate you going over that with us.
Yes, sir.
And I actually wasn't even going to go there that deep into the woods there a little bit. But let's move on to the easement. How is the easement width determined?
Oh, that is a great question. Where's Parker sitting?
Yeah, hi, Parker Rosek again. So 150 feet is pretty much industry standard for 345 kV. So there's a couple things that go into easement width. So voltage is the first one. So the higher the voltage, the wider the easement generally is. And then what we do, and most utilities do, is then design for clearances around that. So you're looking at your safety clearances from the transmission line and then your operational clearances. So ability to work in the easement without having to go onto private property, right? Set up the cranes and the bucket trucks and things like that if you're doing maintenance or during install. We design for clearance to the edge of the right-of-way under all of our wire movement conditions, so under different wind conditions. So that way the landowner is not encumbered on the adjacent properties. So 150 feet allows us to encapsulate the line and make sure we maintain proper clearances and operational ability.
Okay. Because Commissioner Schroeder brought up wind speeds, he brought up tornadoes. Has a line, or not a line, but a pole ever come down because of a tornado? Ever?
Yes.
Okay. So my question is, in regards to the easement width, if you have a 150-foot pole, but your easement's only 75, you're falling outside the easement. So I understand the industry standard, but it doesn't sound like a very good safety standard.
Yeah, I guess it's theoretically possible. Generally, when I see transmission structure, distribution structure failures, the pole doesn't just fall over. There's usually different failure mechanisms that you'll see, and so.
I asked if you've ever had one, if one has ever fallen
You said,
over.
asked if one had failed. I said, you asked, did one ever fail in a tornado?
Yeah.
Yes, that's just said
Yeah.
yes. You didn't ask if it fell out of the right of way. I don't know.
Yeah.
In those situations.
I was just curious why that width was determined the way it is, and then the pole height was where it is, and the home placement. These poles can be upwards. I think Elbert County, you said up to 170 feet. 199 is max, but you're thinking Elbert County is only going to be 170, if I remember correctly. Okay.
Yeah, and I don't know if I get to ask questions of my panel here too, but I just wanted to maybe see if Parker could clarify. It's my understanding, and I just want to make sure I'm correct, that we also have to follow the same standards as other types of buildings in certain ways. And so much like you would see a home, maybe a 2 or 3 story home, doesn't necessarily have to be set back from the property line 2 or 3 stories in height, right? It's set back a number. So it's kind of similar in that same way, I think, in terms of the the setback and
That's
distance
fine.
from.
These are just some, I'm looking through here, just having some questions
Yeah.
in my mind, so I'm just kind of getting them out there and asking you guys a little bit.
Sure.
So another one is a map of burn probability. Did you guys presented us with a map of burn probability, correct?
I think specifically that the burn probability was not our map. I think it was provided by the staff consultant.
Nope, the burn probability map is from the applicant.
We're talking about we can pull it up, the one that was on the slide last night if we want, but sure. If we're talking about the map provided in our application, then yes.
So my question was, is it a map of burn probability before or after the transmission lines are installed?
Patrick, do you want to talk about how we do the modeling?
So I'm not sure on this particular map, but when we look at burn probability and these.
Yeah, I don't know. I didn't understand all the details of it, so I appreciate it.
No, that's totally fine. When we look at burn probability and, when we look at the way we model that at Excel, we have that laid out in our wildfire mitigation plan. And I'm not a risk expert, so I don't want to go too deep into that piece of it. But the burnability model really represents the landscape itself, not necessarily the failure probability or, the asset itself. So it's looking at the, fuels, it's looking at historical wildfires, it's looking at historical weather conditions and understanding what is the burning probability of that environment.
So it has nothing to do with the power line itself?
It has nothing to do with the power lines. It says
okay, I just wanted to clarify that.
Yep.
That's all I needed.
Yes, sir.
Thank you. Photo simulations. What height pole was used in the photo simulations? Because there's a big range. What was it, low hundreds to 170 in pole height. So what height pole was in those photo simulations? Because there was not a lot offered in the way of scale. There wasn't a person standing at the bottom of the pole. There wasn't a car standing, parked at the bottom of the pole to get a good simulation of the actual size. You can see a pole line, transmission lines off in the distance, and it's like, well, I don't know how big that is, and then when you get up and you see them, they look 3 times larger than what's in the simulation.
Sure. The poles represented in the simulations that we include in our application are based on the pole height for that specific location.
Okay, good.
It's provided by engineering at the time we completed them.
Height and width. Okay,
the diameter scale, as a whole.
Okay. I only have 2 more questions, so I'll let you guys off. But desktop cultural resource study.
Mm-hmm.
What's a desktop study?
So
I know they can do an appraisal desktop review, so I know about that, but I don't know what this is.
How do we identify resources sitting at a desk? Is that what you're asking?
That's what I'm asking.
Yeah. So the State Historic Preservation Office maintains a database of surveyed resources, so based on prior studies. And archaeologists, not just anyone can go get that data. Archaeologists that are registered to access that can access those and pull that data down and look at where surveys have been done and if and what cultural resources were identified in those studies. And then also archaeologists can look at the landscape, things where cultural resources may have higher probability to be found along waterways based on historic travel routes. They can look at old trail maps, GLO maps, to gain a sense of that. In the case of certain things in Elbert County, for example, studies were done for different projects. Maybe it was a pipeline going in, maybe it was a roadway. And so we do have some information on what resources were found in those cases for those projects.
Okay. But no boots on the ground studies or analysis, just a desktop.
No, where we have had access to properties, cultural resource specialists have been able to go out and take a look at those.
Okay, good. Great. Mm-hmm. And then my last question is, decommissioning.
Sure.
I know you mentioned you typically, and you used the word typically, don't decommission. But this could potentially be older technology 10 years from now, or 50 years from now, or 100 years from now. And if there's no decommissioning plan, what happens with those towers?
Yeah, so in the event that we do decommission any of our facilities, that's typically approved by the PUC, and there's a plan associated with that. For transmission lines, you're correct. Yeah, we do have some lines in the state that are 60, 80, 100 years old that we're rebuilding. So maybe I wouldn't call it a decommission in that sense, but we could say we're decommissioning the existing line and rebuilding a new one. The poles and wires. In those cases, the wires are removed, the poles are removed or cut below ground, and the area is restored, and the new pole goes in proximate to that. It's, as I was saying yesterday, it's pretty rare that we take a line out and don't replace it with something. And what you mentioned, if there's newer technology or the line is aging and we need to replace it, we remove it and then put the new line in place.
Well, it might not be a line. The replacement might not be a line. It could be something else. It could be obsolete. You don't need that tower at all. That would be my concern. I'm not talking about rebuilding a line or a pole. I'm talking about just obsolete technology. What happens with those poles? I don't want them to be sitting there 100 years from now not being used.
Sure.
So you don't have any plan for that from what I've seen.
No, well, I think in the event that they are obsoleted, we would remove the facilities at that point in time.
But there's no financial guarantee or security bond in place for that in case of that event.
The PUC would require us to do that, and we would finance it. I think it's different than maybe like a renewable development project. I think I don't know if that's
is that in writing? Do we have that in writing? Because I don't.
In terms of
read it. As far as a security bond or a financial guarantee from the PUC, you're saying that the PUC would require it for you to remove those if that ever happened, and I believe you. You look very honest, but I would trust but verify, and it would be nice to have, if we got to that point, to have something in place.
Yeah, to understand that process and where the financial would come from. Mm-hmm. It's my understanding that the developer's agreement, we did provide a brief decommissioning plan in our 1041 application. I don't know if that gives you what you're looking for, if you saw that and didn't.
I did not see that.
Attachment S. We went to double letters. Sorry, attachment S of the 1041 has our decommissioning plan. And then it's my understanding, based on the conversation with county staff in May, that the development agreement would also touch on the requirements around that.
Yeah, because Article 17 and A, B, and C in our guidelines talk to that specifically.
Yep.
And like I said, I didn't see it in the packet that there was any type of financial guarantee there. And then I do have
the financial guarantee. I do not recall a financial guarantee as part of the decommissioning plan submitted. However, there is a decommissioning plan submitted. It is attachment S, as the applicant stated. You're looking for an estimated number for a bond?
Well, that would be nice, yeah.
We do state in that plan that we're responsible for the costs. I think it's in Section 7, financial assurance.
There's just not a number at this time.
Sure. I mean, we wouldn't be able to predict the number if it's 10 years from now. The cost would be different than 20 years from now, then tomorrow, again, that's why as a regulated utility, right, the PUC has some visibility on that and would require us to do that.
Yeah, typically it might be adjusted every 5 years or every 10 years, something like that, because it is too hard to predict what something might cost 50 years from now. So that could be updated periodically.
Sure. I mean, I guess maybe I'm just trying to understand, is the county looking for something there in terms of a bond, or just curious how that would happen?
No, I don't know if the county is, but I would be interested in seeing a bond.
I see.
That's for sure.
Thanks. Yeah, just trying to understand the question.
Yeah. One more question. How many subdivisions are within a quarter mile? I think I saw 6.
I believe that's right.
Okay, because our guidelines address that as well.
Mm-hmm.
And that's one of the reasons I asked you if you were familiar with our guidelines, because throughout the document, it appears you're not. And I don't mean to insult you guys, but there's a lot of instances throughout my reading of the packet where you're outside of compliance of our guidelines. So, for example, Article 17J26D states that they must be 1,320 feet away from a subdivision. And you're saying you have 6, not 1, not 2, not 3, but 6 within that distance.
As I understand it,
go
the
ahead.
code allows for the Board of County Commissioners to make a decision to allow that, with an emphasis on them being co-located, which in the instance of those 6 subdivisions, the route is co-located adjacent to existing linear infrastructure, including existing transmission.
Commissioner Buck, if I might ask a question and on this topic. My apologies for interrupting.
Sure.
The attachment R in the application shows the Elbert County, the overhead transmission lines and existing subdivisions, and the proposed route, and then the distances, as well as kind of zoomed in of where that buffer and setback maybe is not being met. The code section, staff is actually requesting clarification, would like to request clarification from the board at this time on the interpretation of that code section. This is in the supplemental standards in Amendment 4 of the ECZR. I think this is what you're referring to. It's under utility service facility, transmission lines.
I have page 23, top of page 23 of Article 27. It's in there a couple of times. That particular rule is in our guidelines a couple of times. One of them is top of page 23 of Article 17.
Okay, I can pull that one up as well.
I was just asking, I don't think we need to pull it up.
Well, the question...
I was just asking them if they were familiar with our guidelines, and it sounds like 6 of them within a quarter mile.
Well, the staff has interpreted this in a way that might be different from other interpretations. In reading this here, I think the key word is co-location, and what is meant by co-location. If it is meant that co-location means specifically co-location of a proposed transmission line with an existing transmission line, then that would change the review and criteria for this application. You can see in that 25A2 It says may not be co-located within 1/4, a fourth of a mile of an existing subdivision, town, or agricultural development if not co-located, or nearer if approved by the Board of County Commissioners.
Okay.
If the interpretation of co-located could mean the proposed transmission line is co-located with any sort of other existing infrastructure, then that would be different. Does co-located mean existing transmission line? Is that assumed in that, or, you know what I'm saying? Because if it's co-located with a road, that is co-located with an existing road and right-of-way, but that's not co-located with an existing transmission line, and that would be different. That would change the compliance of the proposed route.
Okay. I was looking at our 1041 regulations.
Do you have that section? We can project that section as well.
Yeah, as folks are looking for that, I guess your question was, are we familiar? And I assume
Yeah.
why then are we within the distance? And that is really the basis of it. In looking at what is in the zoning regulation there, it says that it is allowable to be closer if approved and co-located. Agree that the definition of co-location, as I understand it, is not in the code. There's no definition or defined co-location. What that means is it only with a transmission line, is it with other linear infrastructure, as we've interpreted and expressed in the application. And then further, the subdivision, a subdivision in Elbert County, not every single one of those subdivisions, as I understand it, is a residential subdivision, for example. Some of them were subdividing property to a certain acreage, but we don't see that there are development plans for a residential subdivision. So it could be subdivided for a different purpose. And so what is the subdivision? Is it only residential subdivisions, or is it all subdivisions, just even some based purely on acreage? So again, we've presented in the application that the route, when it is within that 1/4 mile of those 6 subdivisions, is co-located with other linear infrastructure, including existing transmission, state highway, and county road. So I think it's a little bit up to interpretation, as we've been discussing, on what does that mean.
Okay. And co-location is great unless you are an affected citizen. I have a lady, the same lady that wrote that letter earlier, she has a core easement of 75 feet. Now she has a Excel easement running parallel with that of 150 feet. Core is running 115 kilovolts. And now Excel is going to run 345 kilovolts. So she's going to have 460 kilovolts running past her house, and the easement just got a lot wider. So it sounds good, and the majority of the time I'm sure it is, unless you're the one affected by it and it's going through your property. So, and I'll finish with that.
Sure. I understand there are certainly opinions on that, and appreciate those. Again, the co-location was an important thing that we heard as we were doing our routing study. I certainly can appreciate that the landowners that have those existing easements may view that differently. But it's a very common comment to co-locate.
Well, one of the things, and I don't know the exact route, but one of the things that I heard was farther east, they had existing lines, larger acreage, less landowners, probably less eminent domain proceedings, and it's flatter. There's not as much wildlife, and there was a lot of pluses to going further out east instead of right along our economic development zone and right past our subdivisions. That was one of the things I heard, and you can correct me if I'm wrong.
I don't in terms of the types of things that are out there, I certainly heard those comments, I think, as well. In terms of wildlife, there is significant wildlife across Elbert County as mapped. That's part of what we look at when we do our routing. We consulted with CPW, for example, even during our routing study, met with them, asked for thoughts and opinions on what minimizes impact to wildlife. And from their perspective, minimizing impact to wildlife was co-location along existing linear facilities.
I did read that.
I appreciate that the landowners may view that differently. One of the things that prevented us from going further east, as was suggested during the routing study, are things like the state wildlife area. The Jumping Cow State Wildlife Area is further to the east. The National Landmark is to the north. So there are significant resources around wildlife and other considerations that are in different directions also.
Let me ask you a question. Was cost one of the considerations?
Is cost a factor in the routing study?
That particular route, a little bit further east, was cost one of the factors that you guys ran the numbers? I would assume as a business you would run those numbers. Was the cost the factor, and what would that additional cost estimate be to have done that on a more eastern route?
Sure. I don't know if, Heather, you want to speak a little bit to the PIM and why. And yes, I will say certainly line length matters. It matters for cost. It matters for construction schedule, two things that are tied to our PIM. But also length matters in terms of impact. If we assume just a general, even certain amount of impact per mile, longer lines have more impact in certain ways.
Depending on how many landowners. Maybe you would have fewer scenic areas. There's a lot of things that would come into consideration, and I was just curious if cost came into consideration.
Sure.
And what that estimated cost might have been, because we're not going to talk about the route today because that's already been predetermined. But go ahead. I'm sorry.
Yeah. So as part of the project and our CPCN approval, we were the PUC did put what they call a performance incentive metric on this project, and they gave us hard targets that we have to abide by on this project. So yeah, we did have a budget that we have to abide by per the PUC. So that's always taken into consideration, and for any project that's taken into consideration. You can get to a project where it's no longer economically feasible to build that project. So we used a rough order of magnitude for cost per mile when we do look at the different routes.
So you could easily extrapolate that estimate, much more linear feet or miles of line on a per mile cost, and figure out how much that additional cost would be.
Yes, that's right.
But if we're talking about cost, is it true that Excel generated $1.94 billion for their investors in 2024?
I don't have the statistics in front of me. Or no, Brandon.
So I have Excel posted $1.77 billion in profit in 2023 and $1.94 billion in 2024. So just out of curiosity, I'd be interested in see what that additional cost would have been.
It's also, we're stewards of our customers' rates as well, and so we have to take that in consideration too. So a more expensive project increases rates for customers, so that's part of why the PUC did give us those cost caps that we need to maintain.
Well, and I'll just finish with this. Part of the PUC's stated mission on their own website is to ensure that investor-owned regulated electric providers earn a return sufficient for their long-term economic viability and their ability to update their physical plant or equipment necessary to provide electric service essential to Colorado consumers. There are 2 investor-owned electric utility companies in Colorado, Black Hills Energy and you guys, Excel. So the PUC's stated mission on the website is to make sure you are profitable. So I'll leave it at that.
And our investors invest in us because they believe there's going to be a return on their investment, right? That's, I think, as you've described, you understand business, right? I think that is also part of the consideration. I think, if it's helpful, we were estimating $4.5 million a mile more, or per mile. Someone correct me if I'm wrong on that, maybe Parker, Heather. 2.4. Gosh, I keep getting the numbers backwards. I did that last night too on cost. So $2.4 million a mile roughly. The other thing that we have to consider as the line gets longer is that per mile cost. But then we do reach a length where we have to consider putting in things like repeater stations or intermediate substations to maintain the voltage on the line. So it can also not just be a per mile transmission cost, but the cost of those interim stations along a longer line are part of that as well.
I keep saying I'm going to end my questions, but I got one more.
But then I keep talking and you have more.
So my last question is, during your open houses or during any of your presentations, did you discuss with anyone the different costs associated with the different routes? I'm not familiar with the different costs for the different routes that you guys explored and did your analysis, so I don't know, but did you go over that with any of the citizens and discuss that, what that cost might be?
Yeah, I certainly was part of conversations with various team members where we explained the cost per mile, what we saw that being, the limitations on length and those interim substations and so on. So
yeah, so if you said to the citizen, well, this route is going to be 50 more miles, or this one's going to be 20 more miles, and this is, one of the reasons, along with this, and this. I was just wondering if you went over that with anybody, because that's definitely interesting information to me.
yeah, I believe we shared that. As I said, I was part of conversations. I believe others were explaining that cost is one of the things, as Heather explained, we're required to pay attention to, and that cost was around $2 million a mile, $2.5 million a mile. So I believe we discussed those at the open houses, yes.
Okay, that's all I had. Thank you very much.
Okay, thank you.
Thank you, Commissioner Buck. We've got a couple of questions for you. I'll try not to get down in the weeds too much here, but we've been dancing around this question that keeps coming up. It's been asked a couple of times. Why are landowners recently receiving condemnation letters when this hasn't been approved yet? I'd like a little more clarification on that.
Sure, I will attempt to clarify, and you let me know if I get there, and if not, we'll keep trying. So schedule and need to continue to access properties require us to not work things in a linear fashion where we finish one thing and begin or do the next. As Heather just described, we have schedule and cost-related caps placed on the project by the PUC. We have to hit those deadlines to put things in service. So as we look at that in-service date and maybe even work backwards from that, I guess, how long does it take to construct the line for that many miles? Then we have to look at what do we have to have in place before we construct the line, our permits, our land rights, and so on, and as well as our design, and we have to have our materials here to start construction. And when we look at all of those things, we have to set then deadlines for ourselves on intermediate tasks. So that includes land acquisition, and that includes permitting. In the case of land acquisition relative to permitting here, we have to move the acquisition forward so that we can get access to properties to do the necessary design studies and environmental studies to then get our materials in place, to have our design completed, and to make sure we have confirmation of any other follow-on permits. So our schedules aren't set up, for example, to have permitting end on the end of the month and we start construction the next day, because there's a lot of in between. The condemnation process as defined as it is, also has a timeline to it. So there's a timeline for those notices and offers, final offers that I mentioned. There's a timeline associated with filing cases, and then either negotiating through to settlement or setting immediate possession hearings. Immediate possession hearings, depending on court dockets, can be set out 3, 4, 5 months from the time we file cases. And then, even that process moves forward later to valuation hearings as part of that process. So getting to the discussion around how we decide values. So in this case, the notices for land acquisition are based on that schedule. We do land acquisition on projects like this, knowing it's somewhat at risk. We acquire the land, we pay for the land in our easements, and in the event that the route permit or a permit is denied, and depending on how that plays out, perhaps we have made that decision to go at risk, but we have to do that based on the schedule.
I guess it seems from this side of the fence, and being a citizen here, and speaking for all the citizens, it feels like it was assumed that this is going to go through regardless. With that being said, then the application was submitted and was not complete. I just want to point that out. A couple of comments I got, not so much questions, but comments I've got. I've got some real concerns. XL has not addressed the potential health risk adequately, in my opinion, to humans or animals. And being a cancer survivor myself, I am concerned about this greatly. So do you want to comment on that?
Are you specifically discussing magnetic fields?
Yes.
Yes, I mean, the body of science really isn't very settled on it. There's a lot of studies. People have their opinions, I guess is what I'd say. You can find a lot on the internet one way or the other. We typically point people to EPRI's research. So I think the website is emf.epri.com. So EPRI is the Electric Power Research Institute. They have a lot of good information on there. The World Health Organization has a lot of good information as well about the risk of high voltage power lines. And then the state has their regulations. So we comply with the state regulations on the 150 milligauss that has the right of way. And I really won't give my opinion on the health effects. It's kind of to the individual whether they feel it impacts them or not based on the body of research that's available.
Sorry, but I just think that the company as big as XL Energy would have some kind of research, some kind of studies to know what kind of impact this would have on people, especially when you're putting these lines across people's property and up close to their homes. It's just my opinion about that. I've heard everything that's been said here today. Yes, this line will reduce property values. I mean, we can dance around that all day. You can't tell me. If I'm going to go out and buy a home and there's a big property line in the front yard or the back and you can look out your window and see it, am I going to buy that? No. So how can you tell me that it's not going to reduce property values? I don't understand that. And as a result of this property line or this transmission line coming through, it's going to impact our cattle industry. And that's our largest industry in this county. And they're already struggling as it is with the economy and the economic downturn that we've had. Nothing has been addressed about that. We talked about our volunteer fire departments. I mean, they are some of the best people around. They do a great job, but they're limited. They're limited on personnel, and they're also limited on equipment. And nothing's been said about, what is XL willing to do or do anything to try to help these departments out once this thing comes through. That's a concern. I have a lot of friends out there, and we just got people and pets and things like that. I hate to think about what, we had a fire like we had up north of Denver. So I'm concerned about that. That has not been addressed. Any comments about that?
I think you covered a number of things. I don't know if you were just asking about the last one.
Let's talk about the fire department and the equipment and current status of that.
Sure. As I think the Big Sandy representative mentioned, we continue to discuss and coordinate with the fire departments to understand their concerns and needs relative to construction and operation of the line. We have a number of miles of transmission operating in Elbert County currently. And so I think part of the discussion is around what is potentially additionally needed for this additional mileage. We discussed yesterday things like situational awareness tools that we're working to make available for the county first responders, like the Pano AI camera access, and talking about and explaining how we access and use the weather station network. So situational awareness tools are important, right? In terms of early detection, and the reference to Douglas County was brought up. I'm assuming folks are familiar and have seen that in the news with those the early detection camera use recently and their ability to go fight that fire. I think Douglas County has also been in the news for their investment in wildfire protection, and that's where we would hope, if Elbert County sees the biggest impact from the pathway project as being wildfire risk, that the development fee would help support that. We'll continue discussions with the fire districts, as we have done around pathway, about what their concerns are, understanding Big Sandy's fee schedule, and hoping to work with them on how to get to resolution on fees that they have.
So this line comes through here, and as I've stated before, it's my opinion, property values will go down. Property values go down, they have assessments that's going to be detrimental not only to the homeowners, but it's going to be detrimental to us as a county when it comes to taxes, revenues coming into this county. I'm sorry, I'm going to say what I got to say. This line serves no purpose here for Elbert County, and frankly, I don't care about Denver and Aurora. I really don't. I'm looking out for the people here in Elbert County, and we've heard from 70, 80 people that came in here and waited through all day, and quite frankly, I feel like some of this is an abuse of eminent domain. I feel like Excel should have come in here from the get-go, from the very beginning. I have followed this thing. I feel like Excel could have approached this a lot differently. I feel like that it could go out east and follow I-70. There are other routes other than cutting through here. And I was raised and taught when I was raised, it's never the wrong time to do the right thing. I personally think that Excel needs to reconsider this power line and the path of it, because it is really affecting a lot of these people moved out here to get away from the city. And some of these people, these property owners, are third, fourth generation people out here, and we're just cutting right through the middle of their properties. And personally, I think they're being bullied. I don't like it. But anyway, I don't have any other questions or comments. Okay, with that being said, are there any additional questions or comments from the board?
I'd just like to make one comment on the quarter mile from subdivisions. I believe, looking at that the co-located is with redundancy on transmission lines, not other linear structures. And so that I'm glad Commissioner Buck brought that up. It was on my list, and I missed it as a concern. And so if there was a unclear provision in a regs, that should have been addressed early on so that there was no confusion at the end. That should have been clarified early on. Certainly is one that needs to be a concern going forward. And I would ask Kelsey if you make a note the next time we look at our reg updates, that we look at clarifying what co-located is. Thank you.
Okay, thank you. Commissioner Buck, you have any other questions or comments?
No, I don't, not at this time.
Okay. That being the case, I will entertain a motion for the 1041 application.
I move to deny the Colorado Power Pathway Major 1041 application, case number 1041-2024-9235, based on Article 17 M1 DFG, M2 ADF, and M4A. I would also like to reference Article 17P, Appendix 1D1, 1E2, 2B2, and 2B5, and Article 17J26D.
Second.
There's a motion, there's a second.
Well,
You need to finish the bottom,
Yep.
sir.
Based on that criteria and for other reasons as described during the hearing, I further move to direct the attorney for the county to prepare a resolution containing findings and the final decision based on the evidence in the record to be reviewed and adopted at a special meeting on July 2nd, 2025.
And that time is 1 p.m.
At 1 p.m. Correct, I'm sorry.
Okay. Is there a second?
I'll still second.
All right. All in favor, sign of aye.
Aye.
Aye. Motion carries.
Mr. Chair, I move to deny the Colorado Power Pathway Special Use by Review application, case number SUR-2024-9236, because of the issues that I brought up before, particularly ECR-ZR Article 3E5, talking specifically about the fire protection and form, and also the road use agreement, development agreement, as well as no agreement presented for the Natural Resources Conservation Services in regard to the Wetland Reserve Program easement. And for other reasons as described during the hearing, I further move to direct the county attorney for the county to prepare a resolution containing findings and the final decisions on the evidence in the record to be reviewed and approved at a special meeting on July 2nd, 2025, 1 p.m.
Is there a second?
I'll second.
There's a motion, second. Any other discussions? All in favor, sign of aye.
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 Aye. Motion carries. Now accept a motion for the continuance of these hearings.
Commissioners,
Yes, sir.
so my understanding, and please confirm this is the case, is that this decision will be finalized on July 2nd. You've given adequate direction to me to prepare those written findings in the form of resolutions, but this decision will not be final until July 2nd. Is that correct?
That is correct.
Okay, thank you.
Yes, sir. I'll now accept a motion for the continuance of these hearings.
I move to continue the 1041 and SUR hearings, cases 1041-2024-9235 and SUR 2024-9236 to a special meeting on July 2nd, 2025.
1 p.m.
At 1 p.m. in the BOCC hearing room, 215 Comanche Street, Kiowa, Colorado, in order to review and approve resolutions containing findings and final decisions.
Second.
There's a motion and a second. Any further comment? All in favor?
Aye.
Aye.
Aye. Motion carries. This time I'll accept a motion to close this public hearing.
Mr. Chair, I move we can close the public hearing on the 1041 SUR hearings, cases 1041-2024-9235 and SUR 2024-9236.
Is there a second?
Second.
All in favor, aye.
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 Aye. Motion carries. I'll accept a motion for adjournment.
So moved.
All in favor? You want a second? All in favor? Aye. Motion carries. We are now adjourned. Thank you for being here.